Okay, good afternoon, everybody. Today is Wednesday, January 31st, 2024. The time is now 1:33 in the afternoon. We're meeting today for a continuance of the Aquaculture renewal hearing for Chris Gargiulo, the president of Katuitt Oyster Company. So this hearing was originally opened on December 12th, and we heard testimony from the public at that time, and Mr. Gargiulo, as well as the Shellfish Constable, and then it was requested that this hearing be continued till a later date. So here we are again. We've received some additional just information regarding public comment from attorneys representing neighbors of the Katuitt Narrows, which were originally the resident group of property owners in Osterville. So at this time, I guess I'll just take any additional public comment that anybody present would like to give regarding anything about the application, please. Sir? Yep. Just please state your name into the microphone prior to starting. Thank you.
Thank you, Mr. Hearing Officer. For the record, my name is Brian Wall. I'm the attorney that represents the group of property owners. And as you know from the last time that I was here, they each own a property on Grand Island in Osterville. And I want to try to not cover ground that I covered before and be efficient, but I have some points that I'd like to make. Yeah,
I think one thing, yeah, I think that's important that I would like to mention. Sorry to cut you off there. Now, the purpose of continuing this hearing was for new information. We're not going to rehash or bring up any of the facts brought up in the original hearing. All that stuff is already in public record. We don't need to go over it again. Yeah.
Hearing Officer Nappy, I know you said this at the previous hearing, but could you just state your name as well for the record?
Oh, yeah, sorry. My name's Chris Nappy. I'm a natural resource officer in Barnstable, and I'll serve as the hearing officer again. Yes, thank you. Sorry, Attorney Walia, go ahead.
Quite all right, Mr. Nappy. So as everyone, I think, at this table is aware, my clients have been trying to prepare their position, and they've asked for public records. And one of the things that I think we've learned is that our position might not be being perceived or received in the manner as intended. My clients recognize that Katuitt Oyster has been in business for more than 100 years. They have tried to make it very clear this is not about shutting down Katuitt Oyster or even adversely impacting it. But what it is about is trying to get some important conditions put onto the license. And we've been trying to make 2 points. One is that there's been a relatively recent change in COC, I call it COC, but Katuitt Oyster's operations from below water gear to floating gear. And the effects of this change on Katuitt Bay and the neighbors, we think, should be evaluated, and reasonable terms and conditions should be placed on the use of floating gear that will allow Katuitt Oyster to continue its business, but will also protect the residents that live nearby. The increase and the change in operations has been documented by Katuitt Oyster's own documents. We have documented a 1,100% increase in the floating equipment since 2006. And what really triggered my client's response is that since 2018, there's been an introduction of new types of floating gear called flow and grow equipment. And this equipment is being located very close in inshore areas, close to the upland property owners and very close to some private docks. We learned from this hearing process that the flow and grow equipment was approved by the Shellfish Constable as a result of a conversation with Mr. Gargiulo. It's our contention that this was done without any kind of evaluation of the effects of this change, without any limits or conditions, or without knowledge of how much equipment was going to be placed or where it's going to be placed, and without referring it to the town manager for further review. It's our contention that this decision by the Shellfish Constable represents a modification and a deviation from established town policy. As I mentioned at the last hearing, there were two decisions in 2007 where the town manager issued detailed decisions denying 2 requests for above-water aquaculture, And he cited many reasons, but including adverse effects on navigation, use of the town's marine resources, and use of the public waters. We respectfully suggest that this kind of change in policy should not be being made by the enforcement authorities, but should be made by the town manager, and that's why we want him to take a look at this. The response from the neighbors should have been predictable by this kind of change. Land uses are traditionally regulated through governmental regulations. Take a single-family home, for instance. A single-family home has setbacks from the road, from the side and rear yards. There are limitations of height and lot coverage. Businesses and commercial activities are separated so that they don't conflict. These types of regulations allow the different uses to exist, but they allow them to coexist and prevent conflicts. Katuitt Oyster is conducting a commercial operation in close proximity to 10 homes and more. My client's 10 homes, but many, many more. It previously was using unobtrusive underwater gear, and the change to above water gear changes the effects on the neighboring properties in a very different and significant way. The fact that the neighbors have concerns about this should be of no concern. This application for renewal provides an opportunity for the neighbors to express their concerns. This is a serious matter. It's a 10-year renewal for 33 acres of property. The neighbors thought that the town would listen to their concerns and take some reasonable action in response, but our research from the town records indicates that's not what's happening. As I said, we think that our position's been misconstrued and misrepresented. And again, as I'm sure everyone is aware in this room, that we've conducted public records requests, and these requests, in my client's view, have revealed that there's bias in this process. COC is aware of this bias and is using it to its own advantage. This is detailed in the materials that we submitted. I'm not going to go through all of that now, but I want to put on the record in a public setting that we uncovered text messages and emails that called my clients NIMBY a-holes, that the constable is disgusted with their behavior, that there have been emails written to DMF and to the U.S. Army Corps that mischaracterized my client's position and called it an all-out attack on Katuitt Oyster rather than what it is to get conditions. There have been communications about this meeting and about communications with town council. This is obviously not fair, and more significantly, the Shellfish Constable is on record as indicating that she feels that the 2007 decisions were, quote, wrongly decided. And this gets me to the following point. The town manager chose to delegate this process to the Natural Resource Department, but it's clear from all these communications that the Natural Resource Department is pro-Katuitt Oyster and anti-neighbor, and therefore we don't feel that we're getting a fair and impartial hearing, and we request that the hearing be suspended and that the town manager handle it from the start. We should have a do-over. Having said all of that, I briefly want to address some of the points that I made before, but I have some additional information. The last time that we were here, we contended that COC does not have its federal permit, and the town and COC disagreed with that. We maintain our position based upon the records that we have, but in addition to that, we uncovered the 1992 original application for the federal permit. And if you go through that application, it's very clear all that was asked for was permission to conduct underwater aquaculture, with the one exception of the Flopsy out by the COC's property. The letter to Mr. Nelson at the time, who owned Katuitt Oyster, states, "You are approved for what is proposed." And so there was no proposal for above water gear, and therefore we contend there's no permit for an underwater, above water gear. Furthermore, we suggest that there needs to be an amendment or a modification to that permit. Our public records requests uncovered some communications by and between the Resource Department and the aquaculturists in Barnstable Harbor. They were seeking permission to have a single floating piece of equipment per grant. And the Shellfish Constable and the Corps of Engineers wrote back and forth to each other saying that there needs to be disclosure of that and a modification of the permit is required. Yet here, Katuitt Oyster is putting in hundreds of pieces of equipment and has not amended its permit. So we suggest that the town needs to look at that, and because your regulations require all permits to be complied with at this time of renewal, they're not in a position to renew. The same thing goes for wetlands permits. There's a letter from CZM that says it's a white paper on aquaculture, and what it says is that there are wetlands permits required, and our research indicates that there are none. The same thing, CZM indicates that floating gear requires a permit under Chapter 91, Section 10A, and we don't see any such permits. Two technical matters. Grant number 3 was changed in size, and the public records request revealed no information regarding this. And grant number 4 was closed to shell fishing for portions of 2022 and 2023. And we respectfully submit that Chapter 130, Section 57 says a grant cannot be issued for areas when or within 2 years it was closed. So we don't think grant 4 is in a position to be renewed. In conclusion, I would simply submit, again, that this hearing should be suspended and turned over to the town manager. If not, we would ask that the permit be granted a renewal for 4 to 5 months so that the town can do an evaluation as we've requested and develop some reasonable terms and conditions. And without waiver of any of the arguments that I've made, if the town decides to proceed with renewal, my clients have submitted some proposed conditions on page 22 of the memorandum that's at the front of that binder that's to your left, Mr. Nappi. We would ask the town give some serious consideration to imposing reasonable terms and conditions.
In this binder or this packet?
The binder, if you open it up, there's a memo, and on page 22 of that.
Tab 22?
No, the very first document,
Okay.
page 22.
Okay. So, yeah, I'll take that into account.
Thank you.
Yep.
That's everything.
Okay. Thank you. Is there anybody else that would like to provide comment regarding the application? Yes, sir. If you could.
My
go
name's
ahead.
Gordon Starr. I'm a town councilor and from Barnstable Village.
Thank you.
I just wanted to point out the fact that Massachusetts is a right-to-farm state, which protects agriculture and aquaculture farms from nuisance suits and matters that impact neighboring properties. So I see this as, floating gear is sort of it's part of the farming process, and it's what people do now. I mean, the bottom isn't as good as it used to be. It's sort of necessary to keep oystering on the south side. So I see it's part of the grant. I think they should be able to do it. So, but that doesn't negate the questions about permits. So that's another whole issue.
Okay.
Thank
Thank you, sir. Mr. Gargiulo, would you like to add anything?
Yeah, no, just a second. Yeah, I know. Yeah. Well, a couple of things. I mean, first off, there was a talk about the Grant 3 modification. And when I purchased the company back in 2004, and prior to that, 2003, there was some changes to the dock area in front of our building, in front of our proposed building at the time. We hadn't even had the permits yet to build our dock and pier. The Grant 3, the way it was configured, was at a real odd angle. It angled off the shoreline out into the mooring field. And when we were proposing the dock and pier with the upweller as part of that proposal, we wanted to make sure that the FLUPSI was in the aquaculture area to be in compliance with state, federal, and town regulations. So we actually reduced the size of the site, reconfigured it so that it would incorporate the dock and the pier, so that our aquaculture area that we were going to be using was going to be in the footprint and not out into the middle of the mooring field, which is where it was designed originally 100 years ago. So it's changed. I'm not exactly sure how that information, I believe our architect at the time submitted some information to make that proposed change to GIS. For some reason it did not make it to GIS. The configuration wasn't made. And then so back in 2018, I believe it was Devin Harrington at the time came out to do a boundary compliance check, as she does with all of the farms. And she said, well, wait a minute, this isn't where, it's supposed to be over here. And I said, well, geez, this was supposed to be changed back in, I think, 2004. And there is some documentation to that. I'll have to do more research to find the original emails, but I'm pretty sure that I can come up with that information. But that was the reason why it was modified. And as far as, as far as the Army Corps permit, I mean, my position on that is that, as far as I'm concerned, I've been operating under the guidelines of that permit since I took over this business. Conversations that I had with Dick Nelson floated gear. He used different types of floating gear in his tenure. And in part of that application, there was mention of floating gear being used. So I don't agree necessarily with what Attorney Wall has said. And as far as I'm concerned, I've been following the guidelines of that permit. And in fact, I think, I referenced the letter that was sent back by the Army Corps of Engineers. I had a verbal conversation with them and a written response from them stating that they reviewed our application, and at the time that these permits were issued, the coverage was for rafts, floats, trays, because in 1992, there wasn't a real full description of what types of gear were being used. So my specific question was, is this gear covered? And I gave them specific examples of what I'm using, and she said it absolutely is, because it is floating gear, floating trays, floating cages, whatever you want to call it. These things didn't exist in 1992. So that was my position on the Army Corps permit. If there was a time where we were out of compliance, I would imagine in the 20 years I've been doing this, that between the state, the federal, and the town, someone would have said to me, you can't do this, or you need to modify this. I get inspected by the FDA, the Division of Marine Fisheries, and the town regularly. And there's never been a compliance issue with my gear. The mention of below surface gear to on surface gear, I've already gone over that in the last two presentations that I've done. It's real self-explanatory. The pictures speak for themselves. I don't think I really need to get into that topic again, but it's a really simple reason is that it doesn't work in a subtidal area, not where we are. That's why I've had to make those changes. I'm adapting to new methods that combat the issues that we deal with on a regular basis. As far as, the rest of the concerns, I feel like I've really tried hard to both educate, talk to these neighbors, inform them, work with them. I tried. And just because someone isn't happy with a view, in my opinion, isn't a good enough reason to essentially shut my business down. And even though that mention of we're not trying to shut the business down, well, you 100% are attempting to do that in many different ways by, crippling my business by not being able to let me float seed to grow the seed so that it's in a healthy environment. I've gone through all this before. If I can't do that, I will be out of business. It's as simple as that. The multiple FOIA requests, the multiple phone calls to colleagues of mine, vendors of mine, friends of mine, neighbors of mine, constantly, I would say, misleading information, misrepresenting what their intentions are, has caused ripple effect for me. I've had to endure that for the last year, almost. So I just ask that you look at this application, understand the history of why we're doing what we're doing. I think you all know why. I think I've been pretty straightforward with all of the people that have worked in the shellfish department over the years. There's been a good rapport with all of the entities that I work with, all of the regulators, state, federal, and town. And I want to continue to maintain that. So I ask that you look at my application and you know, recommend my renewal.
Okay, thank you.
Thank you.
Yeah, Mr. Gargiulo.
There's no one else I'd like to say a few words to you.
1 second. Anything from Natural Resources or Shellfish?
So this hearing initially took place the day, sorry, Amy Croto, Shellfish Constable, took place the day before the Shellfish Committee meeting. And so the Shellfish Committee reviewed the application on December 13th and voted on that day unanimously to recommend renewal as submitted to the town manager. There were 7 or 8 of the 9 in attendance. I can't remember off the top of my head. I know Bob Lancaster wasn't there, but everyone voted. Oh, and Jake wasn't there. Jake did send an email, however, expressing his support for renewal. And the only other thing that has come into our department, and also to be added to the town manager's file outside of the binder that was, I think, on your desk yesterday, the letters of support since the December 12th hearing. There was a letter that came from BARS, the Barnstable Association for Recreational Shellfishing. There was an email and accompanying letter of clarification from Bill Walton, who was used as a source in presentation given by either Mr. Wall, Attorney Wall, or Mr. Cosgrove, and an additional letter of support from the Historical Society of Santuit and Katuitt that have all been added to the file.
Thank you. Mr. Gargiulo?
If I may,
Yep.
briefly, I would ask you to consider in your process of analyzing the information that you've heard orally and that you've got before you written and visual presentations, the way the arguments against the oyster company have changed. You may recall you heard evidence that in the beginning, when Christopher was trying to work with these people, he had to endure threats like, do you really want to fight with a bunch of billionaires? And words to that effect. And he was threatened with financial reckoning, if you will, by several people. I won't mention their names now, but I believe they're in the record from prior hearings. But what we saw in this process before you was an evolution of their complaints. They started off with, and I can recall Mr. Cosgrove saying, well, this is a real danger to children that are sailing in the area, and I'm not objecting to this because of the view. I'm objecting to it because I believe it's a problem and it's a safety hazard for sailing, notwithstanding the Mosquito Yacht Club and their membership endorsed happily the Katuitt Oyster Company and the use of the gear that we're talking about. Then we heard that, oh, no, it's an aid. It's a real problem to navigation, and this is a danger, and it's affecting the waterway. It's affecting the channels, and that's the problem, and you should consider that along with the safety issues. And, of course, that was looked at by the Harbor Master's office, and that was never supported or agreed with or joined by the Harbor Master's office, for that matter, any other experts, any retired Harbor Masters or other experts that might be able to render an opinion relative to that. Not that we can't rely on our own Harbor Master's office, I suggest we can. And then it moved on from there to other things that are in the paperwork that perhaps are not mentioned, like black staining. Black staining is clearly, if anyone who looks into it on rocks, will determine that it's a lichen, that it's naturally occurring, that it's all through the 3 bays. Then we heard, well, we need to do perhaps more studies. They don't mention that the EPA did a study in 2019. One of the samples, in fact, was taken within 100 yards or so of Mr. Cosgrove's waterfront property. All the time, and I would suggest to you all those objections have been presented and have kind of gone by the wayside. And frankly, to suggest that those were the reasons, which is what they were saying to you, I would suggest to you as an insult to one's intelligence. Those were not the objections. They knew the real objection was they didn't like the viewscape. Cosgrove, and my nephew so testified, said, why can't you just move that gear down in front of my neighbors? That would be okay. I'm okay with that. And he said, I'm not going to do that because then it's the same issue for her. That's not right. That's not fair. So the real 800-pound gorilla in the room is they don't like looking at the gear from their $7 to $8 million summer homes. That's the real issue. And finally, we've at least heard some semblance of candor and honesty from Mr. Wall, because that's what it's all about. So I would ask you to dismiss, in your mind, an analysis, or for that matter, the town managers. There is no evidence to support that this is some navigational problem. There is no evidence to support that this is any safety problem. It has the unwavering and extensive support of the entire Cotuit community and beyond. And what really is about is Cosgrove and the few other waterfront folks that he's recruited, none of whom I believe are here, that don't like looking at floating gear, notwithstanding it's cleaning the equivalent of 30 homes worth of nitrogen. So I would ask you to consider that and suggest to the town manager that he consider the benefits, not just to the Cotuit Oyster Company, but to the 3 bays, to the community, to the people that enjoy that waterway. And those are the people that my nephew has always tried very hard to accommodate, and it's evidenced by the letters and the support that you've seen, which, by the way, were unsolicited. If we went out and looked for them, we could have gotten 100 more. So I would just ask you to consider that. This is about people that are there for 5 or 6 or 7 weeks a year or whatever it is that don't like looking at the gear, notwithstanding it's been there for years in a number of occasions, because I looked at the deeds long before some of these folks bought their properties even. So I would just ask you to consider that. Thank you very much.
Thank you, sir.
Might I add to that? And the expression sometimes used, not in my backyard, well, I would suggest that this is absolutely applicable to these folks. That's exactly who they are. Not in my backyard. Put them somewhere else, my neighbors, anywhere, but not in my backyard. I don't want to look at it. So NIMBY, yeah, I think they are, and I use it freely and, happily, because that's truly what they are. Sorry about that. Thank you.
Okay. Any other public comment? Mr. Geiser? Yep.
Conrad Geiser, Cotuit, long-term resident with some aquaculture background and a fair amount of interaction with the Cotuit Oyster Company and Chris. Just want to echo the comments made in favor of the benefits provided by aquaculture and by the Cotuit Oyster Company to the public. And given that the complainants' basis for their complaints presumably are based on public benefit, I think that we can sit down at a table and agree on the public benefits and public detriments, for Cotuit Oyster continuing to do floating gear on their 100-plus-year-old operation. And if that is truly the standpoint of this complaint, I think any impartial panel would probably very much strongly come down on the side of the benefit of any sort of shellfish propagation for the harbor, and especially floating gear, where the floating gear, especially with the eutrophication that's happening in the harbors and the sediment accumulation on the bottom, is almost, I would say, a necessary adaptation for oyster cultivation in the harbor, and is vastly superior to bottom cultivation. And there's been significant developments in floating gear technology and approaches that make that the methodology of choice for growing shellfish. And it's unfortunate that the property owners were, surprised by that. They probably should have done some research before they bought their properties, in that this was a situation that existed and was going to continue to exist. And so it's understandable reactions that are made against these property owners, because if they just took a minute to look at the history and check with the community and look at the benefits versus any potential detriments, their view shed being the primary one in their view, I think they would see the reason in not opposing this. So I would suggest that instead of the complainants continuing to throw flack up, that they actually agree to, maybe an arbitration process of some sort that, really does address public benefit and public detriment to this, rather than continuing to, as it's been pointed out, shift their argument around to continue the fight, where we know that they expect to, grind down the opposition with their war chest. This is not a new story for the town of Barnstable. This is a very, very old story that happens time and time again, and I've been watching it throughout my life, and it does elicit a need for a very strong filter at words that would otherwise be used to describe the complainant's standpoint. Thank you.
Thank you, sir. Any other public comment? Attorney Wall? Briefly, yeah.
Yeah, 1 minute. 2 points with regard to the comment about mediation and arbitration. We have repeatedly asked for that, and we'd be very willing to talk and sit down with a mediator to come up with some conditions. The second point is the following. This is a hearing to allow a private for-profit corporation use 33 acres of public property. The regulations the town has state that the operation in those grants is supposed to coexist with other uses of that public resource. And I think that Katuitt Oyster and my clients can agree on one thing, and that is that conditions have changed. And Mr. Gargiulo has said that he has had to adapt and change his operation. That is what triggered all of this conflict. And I think that what we're asking for is for the regulatory agency to come up with some conditions that will allow the different uses and the different property owners to coexist. That's all we're looking for, is some coexistence. And we're turning to you to help us, despite being trashed.
Can I respond to that?
Yeah, I want to say something too.
Oh, go ahead,
No, you
Kristen.
can go.
Yeah, sure. Go ahead.
The mediation, sometimes known as alternative dispute resolution, this is not susceptible to mediation because, or for that matter, alternative dispute resolution, because we don't have, the Katuitt Oyster Company does not have a dispute with these landowners. We're not in dispute with these landowners. We're in full compliance with all town, state, and federal regulations. There is no lawsuit pending. There is no defined dispute. What they dispute, what they don't like, is they don't like the regulations that we're in full compliance with, whether they be the towns, the state, or the feds. And what they're asking you to do is change your regulations that we're in full compliance with so that they will accommodate their problem with the view, which they don't like looking at floating gear. That's really, if you're going to be honest about it, that's what this is all about. So we're not in a posture to, and I've done 100 mediations and arbitrations. We're not in a posture, we're in no dispute with these people. Their dispute is with the town and the state and the feds. They don't like your regulations. They don't like them because they allow the Katuitt Oyster Company to have floating gear. So if there's to be a mediation or an arbitration, I suppose it's between these 6 or 7 folks and the town, not the Katuitt Oyster Company. We're in full agreement with your regs and full compliance with your regs. They don't like your regs. So the issue is not between they and the oyster company. It's between they and your regs that they don't like because they don't give them what they want. And they tried that with the navigational issue, with the safety issue, and now it's finally down to the truth, which is we don't like looking at the gear. That's really what it boils down to. But the gear is essential. And as the gentleman pointed out, there is a statute, right to farm. And the Katuitt Oyster Company continues and has been in full compliance, dotted with all of those regulations, and will continue to do so. So I would suggest to you, there is no dispute between us and they. They don't have a lawsuit against us. You usually use alternative dispute resolution to resolve a pending legal matter. That's not the case. They don't even have a cause of action against us. They just don't like your regulations, and they want you to change them. So they don't have to look at any gear if they don't like looking at it. So that's, I would suggest to you, the Katuitt Oyster Company's answer relative to mediation and arbitration. We're not a party to it. Their complaint is with the regs, not us.
Okay, thank you. Additional comment?
Christy Gargiulo, I just wanted to say that my whole point in being here today is because you have actually trashed us. Your client has trashed us and has caused a lot of problems for us throughout this whole entire year. And my husband has tried every single step of the way prior to you taking it
Does this have
to this,
anything to do with the
prior to him
regulations?
taking
Yeah.
it to this next
Thank you.
level, to do every single thing he could to educate them and to make this work for them. The only thing that they want is for it to be out of their view. There's no other option that they're bringing to the table. Move it, don't float it, put it on the bottom. And just lastly, I just wanted to ask, and I know I can't ask him, but my 11-year-old daughter wanted to know, and I wouldn't let her skip school to come. If he didn't want to live next to an oyster farm and look at the oyster gear, why did he buy a house next to an oyster farm? And that's the bottom line. Why did he buy it? If he doesn't want to be a part of it and see the process and see the people working out there and see the bags, why did he buy the house right there if we were already there? So that's all I have to say.
Thank you. Any other public comment at this time? Okay, seeing none, we'll take all of this information from both sides and from the town, compile it, and pass it to the town manager. I'm not making a ruling today, either way, but yes, you should have a determination 30 days is standard. So the time is now 2:11, and we can close the hearing. Thank you.
Can I just ask one question?
Yes.
Will we be provided some notice of that? Will we be informed of that when that happens?
Yes.
Okay, thank you.
Can I ask one question before you close the hearing?
Okay.
Yeah. Yeah. Go ahead. Right.
Expires in 2 weeks.
I would say you should operate as normal, as you would.
Okay.
We can expedite, but we have to give 30 days.
I understand that. I just want to make sure that I'm going to be in
Right.
compliance with my license being up.
I think that might be something that you should check with separate counsel on, whether you want to continue operating at your own risk during the period when you're awaiting.
Okay.
If I might clarify, this is not the first time that someone has
Right.
had a license expire during the period of time in which the normal review process takes place.
Right.
Historically, because you followed the regulations to go through renewal prior to expiration, in all other instances where we've had that overlap, people have continued business as usual. In the almost 18 years I've been here, that's not been a problem. and has happened before.
Okay. All right, thank you.
All right. Thank you, everybody. Hearings. Yep.
You close for